I am Tiffany Slone. I am the parent mentor for Northwest Arkansas and the River Valley area. I'm also the Center for Exceptional Families curriculum specialist. And we are talking today to Sierra Glover. She has been nice enough to come on and answer any of our questions that y'all might have. So welcome everybody that has just hopped on.
I'm gonna get over like the lawyerly spiel over
Oh,
with.
by all means, yes.
So just because I'm talking on Facebook Market or Facebook Live does not mean that I have engaged anyone or I'm actually representing anyone. It's just kind of a generic Q&A. For if anyone does want to be represented by me, that's I'm happy to talk to them about that. They can call me at 501-954-9000 and ask for Sierra Glover or my assistant Haley Buchanan. But this does not constitute an attorney-client relationship. So you're back to your question about guardianships versus powers of attorney. That is a great question. Guardianships should not be considered a primary source for most situations. That is kind of the default. It's the it's the last resort. A durable power of attorney does a lot of things. Most people, when they think about estate planning, they think about, okay, I'm going to be deceased or I'm going to be dead and gone in a few years and how to plan for that. But powers of attorney really allow us to have the opportunity to talk about an event that most people experience, which is incapacity or an inability to make decisions. At some point during most Americans' lives, about 70% of Americans are going to experience an incapacity event. And so a power of attorney says during that period of time, that somebody, so a principal, so if I'm going to use myself as an example, a principal will shift what we call their power and an ability to make decisions to what we call an agent. And the agent acts on behalf of that person. Powers of attorney are signed by people all the time. They can either be what we call a springing or a shifting power of attorney. The way that I like to think about that, and I'm sorry, you guys are going to deal with a lot of hokey metaphors tonight, but it's the way it sticks in my brain. When you have a shifting power of attorney, you shift power to another person to make decisions for you immediately. And if you have a springing power of attorney, that only springs into action when you can't make those decisions for yourself. And so those can be as broad or as narrow as you want them to be. And you can make those for both healthcare and financial decisions. Now, those are always going to be separate documents. If you have someone that tries to give you one that covers both, that's typically not going to work. So that's kind of the power of attorney section. And what you end up seeing happen in guardianships, there's a couple of key demographics that I think guardianships are applicable to. It's typically minor children. It is also people that are special needs or have disabilities that are aging out of the school system that may need some more intensive care, may need some help and assistance there, and someone to make decisions for them once they've turned 18. And then you also have situations, I call it my cute little old ladies, cute little old men world. And that is where maybe somebody's having and experiencing significant cognitive decline and they need someone to make decisions for them. And there's always the emergency guardianships that come up. One of the things that I will say about guardianships is that powers of attorney do not require a court to be involved. They are between an attorney or a trusted, you can print them offline. I would caution against that. Obviously, I like to eat and I like to, give people advice where I think it's necessary. But you can go and get powers of attorney without court intervention. Guardianships are by and through the court system. And they are at their core a deprivation of liberty of someone involved. Today I was in court on an emergency guardianship for a minor child, and we vested authority with someone that's not that child's parent. And so that is a deprivation of that parent's liberty to parent their child in the manner that they see fit. And so the court and law, the Constitution, both for Arkansas and also probably the Supreme Court as well, both of those, requires what we call a notice and an opportunity to be heard. So before somebody's rights are being deprived, before an 18-year-old with autism that cannot make their own financial decisions finds out that they need to have a guardian put in place to make those decisions for them, before the little sweet old lady can't, that's been paying the bills a little bit too much and too often, has somebody that kind of steps in and does those things for her, the court is going to want to see the situation and see the person that's going to take over that position, and also the next kind of where we're going to kind of do a check on this and provide that notice and opportunity to be heard. And so the flavor of guardianships is always different. So if there's kind of an emergent situation, and I've had those where, you know, you've got a client that's had a medical emergency and you have to get the guardianship because they don't have a power of attorney, and you've got to have someone calling the shots. You are filing that and you're within a judge within 2 to 3 weeks, typically. And those only last 90 days in Arkansas. That statute is Arkansas Code Annotated 2865-18. So you can get an emergency guardianship. The standard has to be imminent danger of their life or imminent risk of their, you know, property. And so you get 90 days where you get to be the temporary guardian. And then after that, the judge determines whether or not you should become a permanent guardian. If they're a minor child, you can always extend that or continue that process and proceeding for about another 6 months or so. But once guardianships that are temporary terminate, if you run out of time, you have to refile them. You cannot just say, Your Honor, we would like to extend. That is actually what we would refer to as just a constitution. It's a violation of their constitutional rights. You're depriving someone of liberty on just kind of a continuing basis. So guardianships are very costly. Durable powers of attorney when you're talking to an estate planning attorney, those should be a small fee, but it's probably going to be about an hour to 2 hours of the attorney's time max. But the guardianship process is multiple times where the attorney's having to make appearances in court. You will file what we call an annual report of the guardian for the remainder of that person's life. And also, too, guardianships are bifurcated processes. So you can have a guardian of the person and a guardian of the estate. For minor children and for individuals with special needs or disabilities that may be looking at, decision-making authority, you're probably looking at more of a guardian of the person. You want to be able to consent to medical treatments, to be able to do other things like that. Guardian of the person and estate is when you've got finances involved, where you're having to cut checks and pay bills and stuff like that. But also, too, so we talked about, you file this annual report, but anytime that you're doing something that is not expressly authorized in the statute, you have to call, and you have to call your attorney and file a petition with the judge sometimes. If you don't, you're doing that kind of at your own peril on some cases. And it's especially even worse and more concerning when it's a contested issue. So I will also tell all of my clients and and really anyone that's listening, it's my soapbox. If you meet with an estate planning attorney or someone that's going to draft documents for you that govern what happens at your death, make sure that they draft powers of attorney for finances and healthcare. If you just get a simple will and nothing else, it is a deficiency in your estate planning, and it will be something that can be catastrophic in the event that something happens to you medically and your children or your loved ones are left making those decisions without your help and guidance.
So with those two different options, how would a family be able to sit down and decide which option is the best route to go? Or do you recommend going one route if the child, is 18? How do they decide which road in the fork do they go down?
So it really depends on if their child is able to understand it. So in a situation where we've got just a normal 18-year-old kid, no, he's not differently able, there's not any issue like that. That's a conversation, where you still do a power of attorney. Like I have the past bar president for the state of Arkansas. I was talking on this a couple of years ago, and she said, I had that same exact conversation with my son. I told him, I'm an estate planning attorney to some extent. You need a power of attorney. He signed one, and 12 hours later had a traumatic brain injury car accident. And she said that she used it 1,000 times in the next 6 months because he had to teach himself how to walk and talk again. So for anyone, a power of attorney when your child turns 18 is a fantastic idea. Tell them, hey, look, this is only if you're incapacitated. Get the springing POAs, and then do a medical and healthcare, because that is very important. For families that have children that may have special needs, it really depends on their ability that you guys think that you could walk through and kind of sign documents, as far as it relates to finances. And even then, I'm even more prone to say if you don't think that they have the capacity to understand the gravity of what they're giving away, um, and what rights they're relinquishing, because it is a relinquishment of rights and power and like I said, liberty. It's a deprivation of liberty. I would think that we could have a conversation about a guardianship. And emergency guardianships are very cost intensive, but for the most part, guardianship proceedings and guardianship hearings are about, if you do a standard guardianship, you're probably in front of the judge for 30 minutes. You file a couple, maybe it's a couple hours worth of pleadings, and it's not a significant expenditure. And then you're filing annual reports for the next, for however many years you're
Okay.
guardian.
Jerica asked, what age do you recommend getting guardianship?
17.
17
and a half. Yeah. I mean, you're trying to do it as fast as you can because you're going to have a child that's exiting the school system, and there's probably going to be some gaps with care and decision making. But you're really hoping that you're trying to get it before that pediatric care threshold is attained, because I think it's 18 where doctors really don't talk about medical decisions anymore. And so, yeah, I mean, I would say that, if there's a senior year is a really good time to start thinking about those things.
Okay. And somebody asked, what are the legal ramifications for someone taking guardianship that, for example, breaks the law but doesn't understand what they're doing?
Yeah. That's a great question. So is it, I mean, I think that the clarification that you'd have to ask, and I hate to give a lawyer's answer here, but it depends.
Okay.
If you don't file an annual report, you don't have, like, there's not really a massive issue there. They may terminate the guardianship or close it, but what will happen is you pay $50 to the court, you call an attorney and say, please reopen that, and they do it. It is what it is on some of those things. Now, if there's more, I won't say nefarious issues, but if you have a situation in which maybe you've got somebody took $5,000 out of the guardianship account and didn't realize it was a guardianship account, or they thought it was theirs and they just misplaced it and then went, oh, holy cannoli, I made a mistake. If they just move the money over and rectify that, I mean, legal ramifications are a little bit kind of hit or miss. If it's egregious, if it's pervasive, then one of the issues that can come up at times is that can be called, when you're a guardian, when you're an agent, when you're an executor, trustee, any of these terms in the estate planning realm, you are under what we call a fiduciary duty. And that is, your duty is to your principal, who has trusted you and appointed you to serve in that position above all others. There is a duty of impartiality, so you can only prefer that person, over yourself even. You must be fair to them. You must provide them with documentation. You must, like I said, you cannot commingle. And so really it's like, if it's more nefarious, if they're looking at and having a situation where there's been significant expenditures made in the name of the guardian, or if there have been significant sums withdrawn and that's been improperly placed or, misappropriated, that can rise to the point of being what we call a defalcation of a fiduciary duty. And that does have really negative ramifications in the state of Arkansas. I mean, it is whatever you owe, and then there is a percentage of interest, judgment interest, taxed on and kind of tacked onto that. I have seen cases where, gentlemen, a person was serving in such capacity, and he basically took money and said, this feels like mine. And so he was just running through the books up to the tune of about $60,000. And when he did that, we got a judgment against him because he breached that duty. And we said, you paid and used a person who had passed away, who, you assumed this duty. The gentleman had died without a will, which is what we call intestate. And he actually came up and said, I'll serve, I'll do it, I'll step up to bat. And then when he did, he just ran through the money. And so we actually got a judgment against him. So you can be sued for that. Judgment filed against you. And then the judge was going to either force him to liquidate either liquidate property or go to jail until that was paid. And so, I mean, it is not a joking matter. It is not something that should be taken lightly. That is a position of trust. And so the Arkansas Code and Arkansas law reflects that seriousness of that ability and that position.
So if you have guardianship of your adult child, are you held, is the guardianship holder held for legal responsibility if that child, young adult, does something illegal?
No, I
No.
don't believe so.
Okay.
I'm going to say it depends.
Okay. I've actually had a parent or a grandparent that has been very not sure about taking legal guardianship over their young adult grandchild, and they've been told that if that child was to do something illegal or harm somebody, that she would be held liable. So that was my question. I don't know how you can hold that, but
Yeah,
legal stuff is not my area.
well, I mean, look, when a lawsuit happens, we're going to sue everybody in the, and like, I would love to tell you. I mean, look, all of us that are on this, and that anybody that's on a Facebook Live, anybody that's on Facebook, we can disagree about politics, we can disagree about religion, we can all be keyboard warriors. But the thing that we can all agree on today is that we are living in a litigious society. People like to sue people. People like to sue people over what the definition of a dang sandwich is. So yeah, I mean, there's a chance that you're going to be named as the guardian of that person, because if they're under your care and control and responsibility, that is concerning, and that may lead to liability. Yes, but also too, it's the same that you would have. It's the same situation that you would have if you have a minor child in the house that kills somebody in a car accident. Or
Right.
there's a or that they've engaged in nefarious activities or illegal activities that they could be held just as liable. And so for those kind of clients that they're very concerned about that, there is a balance that needs to be struck between the ability to make decisions and also the necessity and ease of, administration that a guardianship provides. I would typically tell them, if they're concerned about that kind of risk, have a very good umbrella insurance policy and insure against that kind of risk, and just make sure that they have a good homeowners policy as well.
Okay. Okay. That makes sense. Let's see. So just so everyone knows that is hopping on, because we have a few more people that have hopped on. We do have a question from Judith. She said, do we need a guardianship account? I've never heard of this. We are filing our paperwork soon.
So if you are a guardian of the person, because we talked about that's a bifurcated process, and most of the time when you have someone that has special needs or a disability, you're not really concerned about getting that guardianship of the estate. You're just wanting to be able to make medical decisions and have that ability. So yeah, I mean, I would always check your pleadings, check and see if that's a guardianship of the person or a guardianship of the person and estate. If that is a guardianship of both, then yeah, you probably will want to establish a guardianship account just to be able to keep things consolidated. Part of what we advise when we talk about fiduciary duties is no commingling. It's all kept separate. And that's because when you commingle, there's such a likelihood that you're accidentally going to double dip, or you're going to pull from somebody's that shouldn't have been pulled from. And that just leads to a nightmare. So I would say, look at your pleadings. If you aren't a guardian of the estate, you have nothing to worry about. If you are a guardian of the person and estate, I would advise to just get yourself a guardianship account and go from there.
Awesome. Well, I will shoot that off and make sure Judith got her question answered.
Can you hear Shelby?
I cannot.
Why not?
No. I can hear, she's really soft, but I cannot hear her. I see her. Hi, Miss Shelby. I still can't hear her. Shelby, I can't hear you.
Maybe it's just my yapping you're catching. What's your question?
Okay. If a, it's a lot of money, disability, a lot of money, does that?
Yeah.
No.
So Shelby's question is, hey, parent guardian just inherited a lot of money. Does that impact disabled child? Does that impact special needs child? Yes, astronomically. And so one of the things that we need to talk about a lot is when we talk about means tested benefits. So most of the people that you're dealing with that are getting government benefits like SSI, Medicaid, those are means tested benefits. So we have resources, we have exclusions, and we have income that we look at as well. And part of our concern is that when you get guardianships, and one of the other flavors of guardianship that I didn't really mention is when you have a large sum of money from like a judicial settlement, like if there's a car wreck case that leaves someone disabled for the rest of their life, you typically see a significant sum of money is given to that guardian, that child, and they're under the age of 18 or they're disabled, and so they can't manage those funds. And that's typically where you see guardian of the person, guardian of the estate happening. One of the things that I would tell that family or that individual that inherits that money is do your own estate planning, completely independent of the child. Absolutely. That is a great time for an attorney to have a conversation with you about the Achieving Better Life Experience accounts, like ABLE accounts for that child to be disabled and to still, the child with disabilities to be able to still make maybe an income or to still have some kind of fund money, use that to have wages. And then we need to talk about third party special needs, or sometimes we call those supplemental needs trusts. Those are really important because that allows that money to be given to the child. Somebody else is going to be in charge of that money, but that gets to work for the benefit of that disabled or special needs child for the remainder of their life. It's not going to disqualify them in any way from their means tested benefits, and it's going to allow them to be able to have that. What's called the key phrase, if you ever are looking at a SNT, is what we call them, is it's supplement, not supplant. So we never get in the way of what the government is supposed to pay out for benefits, but we supplement everything that we can to make sure that they have those expenses paid and covered.
Awesome. Lauren asked, do you suggest having a special needs trust in place before guardianship of a state is put into place?
Yeah, that's Shelby just said, depends on the money. It really does. So
the money is the biggest question.
Yeah. So if this is a situation where you know that there's the inheritance is coming, the judgment is about to be paid out, the number one thing I would do, you're going to keep those funds most likely in the registry of the court, or the firm will hold those in like their trust department sometimes, like their trust accounts. And we will actually set up we'll set up the guardianship, we set up the special or supplemental needs trust. Attorneys use different words. I don't see that. I think it's kind of tomato. But that supplemental needs trust will be set up, and the guardianship will also allow you to say, Your Honor, I petition the court to allow us to set up what we call a trust for that person, that third party special needs trust. And sometimes if that person is not able to do that, then like if they don't have a third party that they trust to do that, or the funds are going to that individual directly, what they'll end up typically having to do is set up what we call a D4A trust, which is a self-settled supplemental needs trust. Those are different. The rules on those are different. So there's first party SNTs and third party SNTs. Third party is, we try not to hide the ball. We use enough Latin in our practices enough already. It's annoying. But third party SNTs are when a third party is establishing that for the benefit of a child with disabilities or special needs. A first party SNT is often referred to as a D4A trust. We are not original. We're not trying to be funny. It's the code provision of the United States Code that tells us that that person and that child and that individual with special needs or disabilities can set up that trust for themselves. There are very specific rules for D4A trusts. And so if you are dealing with a situation where there is an inheritance that's, pre-death planning, go talk to an attorney and get that set up beforehand. If there's a judgment or there's an inheritance that's coming after the fact, you're probably going to be in D4A trust land. And so you have to kind of get that process in place, because if it goes outright to that beneficiary or to that individual with special needs or disabilities, they are going to lose their benefits.
Talking is, 6 plus everything. We're talking doctors, medication, everything. Because this is not just a SSI check, everything goes on until he turns 18.
Yeah, and that's, I mean, so one of the things that I cannot stress enough for people is to talk about it. That sounds really dumb and that sounds really hokey and like simple, because people don't want to talk about their business. They don't want to talk about finances. But what ends up happening sometimes, and you get those people, is that so my practice focuses pre-death planning and post-death administration. And I have had post-death administrations where I am dealing with people that are left in the aftermath of someone who never talked about their planning, and they're going, I am on the worst kind of choose your own adventure story. I'm finding all of these things that I don't know if they even are deals that this person is doing or investments that they had. I don't even know that those exist. At the very least, talk to your family, talk to your loved ones, talk to the people that are going to be serving in these roles, because it's so critical. And then, like Shelby's saying too, have multi-generational estate planning. I'm not saying go to the same estate planning attorney. Estate planning attorneys, CPAs, financial advisors, doctors, we're all like shoes. It's just sometimes not a good fit, and you got to go to somebody else, or you like somebody else. But find that person, do planning, and talk about planning, because when you do multi-generational planning, in this context especially, you will maintain benefits for the remainder of people's lives. Also, if you do multi-generation planning, you have the unique ability to create generational wealth in some instances from estate planning. And that is wealth, like that is the stuff that the Waltons, the Rockefellers, the Kennedys all have done. Like, we're not reinventing books. We're not reinventing the wheel here. But what we are doing is using those same tools and kind of the tried and true methods to make sure that this is allowed to grow and continue to grow in a way that is beneficial for future generations.
Awesome. We have a question. There's a family that is getting ready to file guardianship for their 17-year-old low functioning child. That child does not have SSI yet and no inheritance at all. What are the steps for them? Or is like it just a basic guardianship?
That sounds like to me just a pretty basic guardianship. You're going to want to do a permanent guardianship. So you're not going to go through the emergent route like I was talking about with 2865-218. You're going to go straight guardianship. You're going to have a hearing. You're going to be appointed permanent guardian. You're going to be in court for probably 30 minutes to an hour max that day. And the judge is going to be pretty fast. You get qualified as a guardian. You typically need to go talk to your physician and get a physician's affidavit to add to that as an exhibit to that petition. You don't have to call your doctor to get there. You just have to have their signed affidavit under seal, have a notary sign it. Your doctor's sending you something that looks like your kid is not going to be able to go to, school the next day is not sufficient. It's got to be signed under seal. And there is actually a standard that is under Arkansas law for physicians' affidavits. There are 4 categories that are required there. And under those 4 categories, that physician needs to make assessments. And I'm not coming off the top of my head. I can't remember what those are. I think it's 2865-205, 2865-201. I'm actually pulling it up on my phone right now because I just had to send it to somebody a few weeks ago. So, but it deals with the current condition of the proposed ward. And that's the language that we use. So we have guardians that are getting the guardianship. Those are typically referred to as petitioners in the court pleadings. And then we have what we call a proposed ward, is someone for whom a guardianship has not been appointed yet. And a ward is someone for whom guardianship has been appointed. The physician's affidavit typically requires that individual to determine how they're incapacitated. That's either mental illness, mental deficiency, physical illness, chronic use of drugs, chronic intoxication, or other. That's 2865-1015. And then they provide a mental and physical condition, adaptive behavior, intellectual functioning, recommended specific areas of assistance, and least restrictive alternatives. So that is if you do not include those, you do not state those, and that affidavit does not include that information, it's, if you've got a judge that's going to look at the code closely, that will fail as a matter of law. And that petition will have to be extended, and they will probably do like a temporary guardianship and then make you get back in court. So the physician's affidavit is really important. And they will actually, they want you to kind of say, you know, how long you've been the physician and when the most recent time you've examined that person is.
Is the judge going to want to see, or is that child going to have to be in the courtroom with them? So they do
Yes.
have to go that day.
Yes, and I will tell you too, when I've had that situation, so I represented a family about a year ago that had this very situation happening. She was 18 and a half, and mom was like, I have been told that I am a terrible mother because I did this. And I waited. I didn't know not to wait. Like I didn't, you know, she was like, I wasn't educated on this. And the judge, the proposed ward believed she was going to be arrested that day. She did not understand why she was in court. And so, you know, one of the things that I did was I actually walked up to the bailiff, I walked up to the trial court administrator, and I said, she is terrified. Can we do anything to put her at ease? And we were in front of Judge Sean Johnson in Little Rock and Pulaski County, and he was amazing. He let her take the stand. He let her talk. He was like, you know, you're not in trouble. We just want to talk to you, kind of see where you're at. And he let her talk for 10 minutes and then was just like, you have a team of people that love you and care about you. And that's why we're here today. And we cannot wait to see how you grow. And like, we are all on the same team with you. And that's the kind of like, that's a perfect day to be a lawyer. You don't get perfect days to be a lawyer every day. Sometimes those don't happen. But I would advise, you know, there's the practice of law component and being like a human with emotional intelligence and understanding your clients. And that's something that some attorneys are great at and some attorneys are not so great at, but they get results. But just having someone that can kind of go and tell the judge or the bailiff, like, hey, she's nervous or he's nervous about this today. And just being able to talk to the person about, you know, hey, this is what we're doing. We don't make people do anything out of fear. We educate people, we empower people to make decisions and to feel like they understand what's going on around them.
Do caregivers, Kimberly asked, do caregivers need to file for guardianship before filing for SSI or after? Or does it matter?
No, it doesn't matter at all. That child's needs are independent of the guardianship.
Okay. And so like how often, if they file the guardianship before they do the SSI, do they need to go back in and update anything once they get the SSI benefits?
If they're the guardians of the estate, they may want to get the SSI check deposited into that estate account, but that's about it. That's the only update I would make.
Okay. That makes sense. I'm waiting to see. Shelby, do you have any questions? Because
yeah, she's actually, I'm like in the audible right now, like yeah. I'm in the helmet. Yeah.
You know, so it's not
yeah. So it's always, I will never, one of the things I think that attorneys are terrible about doing, and doctors too, we have bad bedside manners where we're like, oh, why did you not do that? That makes no sense. Shelby's right. You don't have to get a guardianship. Most people operate under no guardianship for years and years and years, and it's fine. The only concern that happens sometimes is when maybe medical decisions are being made, and then that's maybe kind of the kink in the plan, or, you know, it kind of throws everything into a bit of chaos. But I mean, if you've got compassionate doctors, if you've got good people that know you and know your situation, for the most part, this doesn't have to happen. But it is preferable, but it's not something that, you know, if the child turns 18 in one day, that, you know, you're failing as a parent. You're already taxed and overburdened enough as it is. You're doing the best you can. If you get it, that's great. If you don't, you know, you can get it. It's in the future. It's okay too.
okay. Well, and that kind of goes with school too. The school should still work with you if your child is still in school, you know, after they turn 18. The school should still work with you and communicate with you. Ruth just posted a question. She says, guardianship works for some of our children. we have guardianship of one of our kids with disabilities, but for the other one, guardianship wasn't the best option.
Yeah.
So it's kind of, you have to look at each child in that sense of what will fit for them and what will best work for them.
And that's one of the things that I think that a lot of people get, they believe that, you know, I see it a lot in more of like the estate planning side where they're like, I don't need a will, or I don't need a trust. I'm not, I don't make enough. I'm not Jeff Bezos. I don't need a will, or I don't need a trust. I'm good. I just need my beneficiary designations. And I'm like, well, no, like you do need a will. Like, you know, there are people that even if, yeah, and some people need trust, you know, but it's estate planning, guardianships, any kind of these intervention plans that we have for people, or any kind of the planning that we can do, it's not a one size fits all. It's just not. There are people that, you know, like if you have a situation where maybe there's somebody that's in your home that you're taking care of that is not with, you're not their biological parent, and you're married, or there's other situations like that, you may look at, you know, do we adopt? You know, is that the best course of action, or is there a guardianship that's the best course of action? You know, there's 1,000 different options that we have, and so like Ruth said, there is some people, and there are some situations where it's just not the best call, and that's okay too, and it's just based on circumstances.
Where do you recommend folks go? Because since we're live for the whole state of Arkansas, is there like a website where they could go and kind of see a list of attorneys that specialize in this, or what should they be looking for when they do their internet search to find the right fit?
Ooh, well, I'm going to shamelessly plug RMP here because we are, so I'm an attorney with Reese Moore Pendergraft. We are in the Jonesboro, so I'm currently in Jonesboro because we have a Jonesboro office on 710 Windover Road. I actually practice out of the Little Rock office, which is it's on Pleasant Ridge Road, right across the street from Santo Coyote in the Pleasant Ridge Development Center area in West Little Rock. And then we also have an office in Bentonville and in Johnson/Springdale area. So we are across the state. But there is also like the Arkansas Bar Association. I think they have the Find a Lawyer services. And I might be being a bit elitist here, but I'm willing to make that argument. I don't think that you should go and have a guardianship done by somebody that will do your divorce, your criminal case, your probate, your guardianship, your SSI, your Social Security. There is something to be said about being a jack of all trades and a master of none. The attorneys that I'm talking about at RMP and at other firms, if you know somebody that has look for certifications. Look at someone who has been doing this for a long time. And I know I say that I look like I'm 12 years old sitting in front of you, but look for someone that's been doing this. But look at someone that's been practicing longer than 2 years maybe. Look for someone that has certifications. If they're a national elder law or National Association of Elder Law Attorneys, that's a great one for elder law planning. If they are someone that's an ACTEC fellow, that's the American College of Trust and Estates Council, that is a fantastic attorney typically, because they have been practicing in estate planning 50% of their practice for 10 plus years. It is a very elite group of attorneys, and they do good work. For the most part too, though, the biggest thing that I would tell you is call an attorney that you trust. Call someone that may know people, and then talk from there. I had a situation in the last couple of weeks where somebody reached out to me and said, who's the person that takes care of that? And I said, I don't feel comfortable recommending you to anyone, but I know I got it, and that happens. But if you can recommend someone to me, or call me and say, hey, Sierra, I'm in Southeast Arkansas, who do I get? Or hey, Sierra, I'm in, middle of Central Arkansas, who's the person? My contact information is S Glover, so SGLOVER at rmp.law. My office number, like I said, is 501-954-9000. Office direct line is 479-502-9548. call those. Talk to me. If I can't find someone that will help you, I'll make sure to make a couple phone calls and call around, and we'll get you someone that can. Because I'm not pretending that I have all of the answers. I don't. If you told me that you wanted me to tell you about criminal law, get ready, start working on your prison routine, like your fitness routine. It ain't me. It's not me. So.
Awesome. Shelby, do you have any other questions? Because I don't see any other questions posted. I know you just gave the 15-minute, warning for the end of the question and answer. So
we actually, and one thing I do want to mention, just because I shamelessly plugged RMP, I believe that the Arkansas Bar Association has a member directory, or has like a directory of attorneys that are in an area. Google reviews are kind of hit or miss. Somebody's always gonna have bad experience. Don't hold that. Look for an attorney. Some attorneys do charge an initial fee. Kind of check that. Most attorneys don't. Have a conversation with them, because it's really just about fit. If you don't feel like there are people when they call, and I'm not a divorce attorney, and they'll call me and say, I need a divorce attorney. And I'll say, do you want a bulldog? Do you want somebody that's going to be, treatment kind of, because they'll be like, yeah, I've got a lot of trauma from this relationship. I need to work through that. And I'm like, do you want trauma informed representation and kind of assistance with that? Because I have people that I know that have their masters or their in social work. And so they have kind of a trauma informed representation, and that really helps a lot of clients. So that's kind of, I need to know if I need to send somebody to go just pound the table for you, or if I need to have someone that works with you to kind of understand everything that's going on and show a little bit more empathy with your situation.
Awesome. Well, I appreciate you spending this time with us and answering our questions and being with us. And I just want to let everybody know that if you have questions, you can always go to our website, which is the Center for Exceptional Families.org. And our parent mentors are listed on there, and you can see which areas they cover. I cover Northwest Arkansas and the River Valley, but if somebody reaches out to me and it's not in the right area, I will direct them to the correct parent mentor. And we can always send out your information if anybody, contacts us and missed your phone number, email address. So we will gladly share that.
Shelby had one good question, which was a follow-up of, can your guardians change? The answer is always yes. So there's a distinction here between a successor guardian and a standby guardian. Standby guardians can be appointed for anyone as long as, it's like a parent that's like, I don't feel like I'm going to be around on this earth for very long. I'm going to name this person as kind of a standby guardian for my kids. That can happen. And I can't remember the statute off the top of my head. Sorry on that one, but you can do that where it's like, I think that I'm under imminent risk of death. And so I'm going to kind of name this person. And Arkansas law also, when you have estate planning that you do with an attorney, or even generally, like if you do your own, your will should nominate a guardian in addition to an executor if you have minor children or a child that's got special needs or disabilities, because Arkansas law does give preferences to someone that you've appointed in a written instrument if it's your minor child. There are also what we call successor guardians, and those are under, I think it's Arkansas Code annotated 2865-220. In a minute, but I think that's it. And the successor guardians are someone that can basically, they take and kind of step into that same role. The original guardian could have died, become ill, incapacitated, unable to continue in that role, and that successor guardian can kind of step in. Sometimes you see that, clients get older with age and have, age-related decline, and so they'll nominate or, petition to resign with the court, and then have the court receive a new petition for someone to be serving in that role as a successor. And all the duties that we had attached.
Awesome. Well, I appreciate you spending our time, Sierra. Thank you again for that. And thank you again for being a board member for our organization. Y'all are very precious to us, and we're grateful for all of you. Shelby, thank you for hosting Sierra this evening. And I want to give a shout out to Michelle for helping me get this little hiccup at the beginning onto Facebook Live. So we appreciate you spending the time. Again, if anybody has any questions and missed out, feel free to go to our website and find your parent mentor or reach out to Jerica in our office and ask your questions, and we will get back to you and help you as best as we can. So, Shelby, do you have anything else you want to add or say?
When will it be on the Facebook page?
It's streaming right now. We're live on the Facebook page right now.
And YouTube?
I will look at getting that on. I will talk to Michelle, and we will gladly put it onto YouTube because, hey, I need to go back and listen to it sometimes because I miss information, especially when parents ask me. I'm like, hold up, let me send you a link to our YouTube channel. So we will work on that, getting it up and posted. But Sierra, I appreciate it. I'm sure we'll get some calls and you'll get some calls, and hopefully we can do this again in a few months and just refresh it and answer more questions.
Sounds great. Thank you guys so much for your time.
All right. Thank you. Have a great evening, everybody, and we'll see you next time. Bye.